I'm Rob Hassett. I'm a lawyer in Atlanta. I mostly do work in the entertainment and technology areas. And I did a few years ago create a video about what I consider to be the 5 biggest mistakes I see in connection with limited liability company operating agreements. And what I'm going to do in this video, this is an update to that video, a replacement for it because it's a little out of date. It was very popular. So I'm going to give you my what I consider the 6 biggest blunders made in connection with limited liability companies. The To start, I want to give you my disclaimer. This is not legal advice. This is for educational purposes only. You have to hire your own lawyer if you want legal advice. The 6 blunders I'm going to talk about are not in any particular order. They're just all I consider to be important. The first is a failure to provide clean way for the parties to separate. This could be done in different ways and should be done different ways depending on the situation of the parties. If the parties, one of them is a real visionary and the other just came in to help, then the first party, the visionary, should be able to buy out the, um, the later added person. If the parties are fairly equal, then you can put something in like, I agree to buy you out or sell you my units at a certain price, and you have the option to do either one. The second major blunder I see is paying a commission to someone who brings in investors who's not a broker-dealer, a registered broker-dealer. That's illegal in most states, and that's a problem. Third is the fully vesting the founders. If there's more than one founder, you don't want to have everybody start off with 33% of the company, for example, for 3 founders, and later find out that they're not going to contribute what you expected them to. That one is not going to contribute as expected. To avoid that, you have the units vest over time. There's various ways to do that. You do want to make the tax based on the value when the company starts, which you may need a Section 83 election to do. It's called Section 83, as opposed to having the tax based on the value of the company 4 years later, which might be a lot more. Hopefully would increase a lot and make the taxes higher. So you don't want to avoid that. The fourth is ignoring or being unaware of the peculiarities of applicable state law. The laws for limited liability company varies from state to state. In Georgia, we have one of the concerns I would have is our default rule that applies if the limited liability company operating agreement doesn't say otherwise, that voting is all per capita. So if I own 90% and you own 10%, we still have equal vote, which would not be something I would want if I own 90% or expect. The fifth is relating to tax issues. You can elect to have a limited liability company taxed if there's more than one member, as a partnership, an S corporation, or a C corporation. And I'll give you an example of if you're taxed as a partnership, the problem is, it can be a problem, is that your what are called guaranteed payments, or the equivalent of salary for members of the company, are not generally considered wages. And that affects different things, such as it impacts the pass-through deductions under the 2017 Tax Cuts and Jobs Act, and you may want to have part of the payments made in wages because of how it affects the amount, the up to 20% deduction that can be made from the pass-through portion of the income of a company. Here's another situation that comes up under state law in Georgia. We have tax credits for the entertainment industry, especially for film and for video games. And and that tax credit can be up to 30%. It's not a deduction, it's much more valuable. It's a credit and can be sold to the extent you're not using it. But you have to have a minimum threshold of $500,000 in expenditures for movie production in Georgia to use it for movies, and $250,000 to use it for video games and payroll for video game development in the state of Georgia. So the problem is that if you pay that money out if you tax your company as a partnership, it's elected to be taxed as a partnership, and you pay that money out to partners, then then those guaranteed payments don't count toward that $500,000 or that $250,000, but you can count them if you pay it as wages. As an S corporation can pay part of the money, can pay out money that it makes as wages, and C corporations can too. So you can see that can be a huge difference. You could get, if you had 400,000 in expenditures for a movie in Georgia for movies in 1 year, and you needed another 100,000, you might be able to make that by payments to the to as wages under an S election or a C corporation, but you couldn't as a limited liability company. And 30% of expenditures is a huge huge benefit to the movie makers or the video game developers. The sixth blunder I see is a failure to have the founders of the company assign all their copyrights, trademarks, and patent rights to the company. Failure to do that can lead to a lot of problems later. All kinds of security lawsuits, can cause the investors to not get the value of what they expected, etc. Appreciate you watching this video. If you have questions, you can call me at 678-506-8828 or email me at rob@businesslawpartners.com.